don't know how many of you have had clients who were pristine while the other side was all the bad guy. And so I think that's the other really helpful thing as it relates to this hypothetical, is that every client has their own issues. And so while they're in there telling you all the bad things that the other side did, A, maybe they benefited from it and were fine with it during the marriage. And B, perhaps they have their own issues that from a client management standpoint, it's really critical that we're prepared to deal with our clients.
So generally, we're going to be addressing the duties that attorneys have to their clients, possible consequences to the attorney if they decide to assist their client with their deception, and then to work on providing some advice that you would want to give to your clients. Sandra, what duties do you have to your client?
Well, the attorney has a number of duties that they have to navigate in this situation, which can be a little bit tricky. First, there's obviously the duty of competence. So lawyers need to apply the learning and skill reasonably necessary to discharge their duties effectively. And if the lawyer does not have that learning and skill, the lawyer can still discharge their duties competently by either consulting with or referring to a lawyer who does. So for example, the tax and offshore issues that are raised here would be appropriate for that kind of a referral or consultation. And then the attorney also has a duty of candor, both to the tribunal, lawyers may not knowingly make a false statement to the court, and also to third parties, including the opposing party. In the course of representing a client, a lawyer may not knowingly make a false statement of material fact. And then there's also, of course, the duty of confidentiality. Over and above the evidentiary privilege, attorneys are required to maintain inviolate their clients' confidences and to preserve their secrets. And then in addition, attorneys have a duty to uphold the law under the Business and Professions Code and may not counsel clients or assist clients in perpetrating a crime or a fraud. So taking all of these duties together, the attorney probably needs to recognize that he or she is not qualified to handle some of these issues and to bring in a qualified attorney with expertise in those areas. With respect to Rex and Priscilla, the attorney has to advise the client that they need to disclose all of the assets in accordance with their fiduciary duties. And in doing so, the attorney also needs to inform the client of the likely consequences. So if you come forward and admit that you did all of these things, there is something of a target on your back. It's likely that the other side will try to use that against you, and it could result in some challenges with credibility. And then if the client refuses to disclose against the attorney's advice, the attorney needs to either withdraw, or if the attorney hasn't already accepted the engagement, don't do so. And then, of course, because of the duty of confidentiality, the attorney can't then go and tell anyone what the client has told them or why he or she withdrew. So, Judge Goetz, what can happen to the misguided attorney who does not act in accordance with his or her duties?
All right, so I'm going to go from what would, in my opinion, for me, be the worst to the least worst. None of these are good. Pursuant to Penal Code Section 127, willful subornation of perjury is punishable as perjury. So what that means is if you are, as an attorney, know that your client is going to be testifying falsely, you're suborning perjury. And perjury is specifically identified in Penal Code Section 118, which is defined as deliberately giving false information while under oath. And one interesting point about that is, as I was preparing, there's a whole list of things that are considered perjury, but one that kind of got me by surprise was if you don't know something, but you testify affirmatively to something being as fact, that's perjury. So you have to be really careful in terms of what would fall under that definition. Perjury is a felony and it carries a maximum of 4 years in state prison. Now, under Business and Professions Code Section 6128, not a felony, it's a misdemeanor. It's a misdemeanor for an attorney to deceive or consent to deceive a court or any other party. And the penalty for misdemeanors is up to 6 months in the county jail and or a fine of $2,500. But I think after that, you're going to have problems with the state bar if that were to happen. If an attorney attempts to hide a client's income and or assets from the government, then they can face federal criminal liability. So one thing I learned when I was in the district attorney's office, I was cross-designated as an assistant U.S. attorney. The one group of people I would never want to get investigating me is the federal government. They've got unlimited resources. So it has real teeth if you were to get involved in trying to help your clients hide some assets. The least worst is Business and Professions Code Section 6106. An act, 6106 says that an act is considered involving moral turpitude or dishonesty is equal to grounds for disbarment or suspension. So if you're helping your clients do things that are against the law, it can result as a question about your moral turpitude or your propensity for dishonesty and can affect your license to practice. So Sandra, Rex is coming to you for advice. What would you tell him?
Well, as I said earlier, I certainly would immediately refer him to or consult with a qualified tax attorney to address the issues and suggest that they explore the possibility of a voluntary disclosure to the taxing authorities. I would advise Rex that he has to disclose all of the assets. And then I would also recommend that we solicit Priscilla's cooperation in trying to minimize the tax liabilities vis-a-vis the taxing authorities. They have plenty of time to resolve their disputes over the allocation of the liabilities in the marital dissolution proceeding, but task number one is to limit the damage vis-a-vis the taxing authorities. So you might propose a stipulated order that the parties are going to cooperate, but that they preserve all of their claims against each other in the marital dissolution proceeding. And then I also, since Rex mentioned that he's been snooping around in Priscilla's books, I would want to make sure to caution him that his sleuthing could get him in some trouble. So electronic eavesdropping is a crime under California Penal Code Section 632, recording without consent, spyware, keystroke logging software, all of those things are no-nos, and you don't want to accidentally commit a crime in your zeal to uncover information. And likewise, opening mail is a federal crime under 18 U.S.C. Section 1702, punishable by up to $250,000 in fines and up to 5 years in prison.